Good morning, if anybody's coming in. We are going to talk about the case today, Villarreal versus Texas. Oral arguments are going on for Villarreal versus Texas today. It's an interesting case coming out of the Texas Court of Criminal Appeals, which is a Sixth Amendment challenge saying that not allowing a defendant to confer with their attorney about their testimony during recess is a violation of their Sixth Amendment right to counsel. So we're going to be talking about that today. We're going to be listening to oral arguments. I am literally waiting for them to start right now. I'm going to refresh this real quick and see what I can get. Let's see. Okay. We're just waiting on it to start. Good morning, everybody. I'm going to be doing Villarreal versus Texas today. Couple of interesting things going on with it. So sorry, that's not me, that's them.
The Honorable, the Chief Justice
here we go.
And the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Is everybody able to hear?
I have the honor to announce on behalf of the court that the October 2024 term of the Supreme Court of the United States is now closed, and the October 2025 term is now convened.
Happy SCOTUS
Today's
Day,
orders of the court have
everybody.
been duly entered and certified and filed with the clerk. Mr. Clerk, the court will entertain motions for admission to the bar of the court.
Andrew Tutt.
Mr. Tutt?
Mr. Chief Justice, and may it please the court, I move the admission of Samuel Isaac Ference of the Bar of the District of Columbia. I am satisfied he possesses the necessary qualifications.
Your motion is granted and the applicant will be admitted.
Brian Shade.
Mr. Shea?
Mr. Chief Justice, and may it please the court, I move the admission of Priscilla Bonsu of the Bar of the District of Columbia. I am satisfied she possesses the necessary qualifications.
Okay.
Your motion is granted and the applicant will be admitted.
Tina Fox.
Okay, so we'll talk here just for a minute about the case that we're doing. So Villarreal versus Texas. So he was on trial for murder. It was actually a very kind of big case out of San Antonio. He went on the stand as a witness, obviously for himself and the defense, about self-defense. However, they took an overnight recess while he was giving testimony. So, when they took this overnight recess, the judge said, hey, you can talk to them, you can talk to your defendant, but just not about their testimony at all. So Villarreal is now arguing that that is taking away his Sixth Amendment right to counsel. I think a lot of us think about these things and we're like, well, why wouldn't you talk to your attorney about your testimony? Most people do, but it comes from this sort of like arbitrary rule of like no coaching and keeping your testimony pure. It's not really a rule per se, but either way, the circuits are super split on this. And so that's what they're going to be arguing today. It looks like they're admitting new people. We're hearing some audio from that, but I'll restart and see where we're at. Hold on.
Caitlin Elizabeth Ames. From the Bar of the State of Georgia, Victoria Diane Starks Neighbors. From the Bar of the Commonwealth of Massachusetts, Hannah Ruth Marsdale. From the Bar of the State of North Carolina, Desiree Lynn Clem Kafel. From the Bar of the State of New Jersey.
Okay, so a lot of like pomp and circumstance going on. So it's based on, what is it? Is it Getters? I think it's Getters. Hold on. Give me 1 second. Yeah, Getters v. US is sort of the precedent in this case. Or Gettys, sorry. Wait, what am I thinking of? Hold on. I'm thinking about something. Can't remember the case right now. Getters. Right to counsel. Sorry, I'm getting the name mixed up. Give me 1 sec. Okay, yeah, it is Getters v. US. Okay, I knew I wasn't crazy. Yeah, it's where the trial court prevented the petitioner and defendant from consulting with his counsel about anything. Although in this case with Villarreal, they kept it specific to testimony. It doesn't really matter because the question ultimately comes down to, are they violating a defendant's right to counsel guaranteed to them by the Sixth Amendment? I think most normal people agree that when a judge is like sort of arbitrating what you can talk to your client about, that's certainly going to be problematic. Of course, there are certain stipulations, like if you're admitting to like an ongoing crime, you obviously can't do that. But yeah, it's certainly interesting. I kind of want to see how this plays out because no, they don't have a right to ignore an order like that. They do have to follow the judge's orders, which is why we're now at SCOTUS with this case. So yeah.
The defendant's testimony. Our brief has many more examples, but the point is that the defendant and counsel often must discuss the defendant's testimony during an overnight recess.
We just started.
Now, the court below tried to distinguish between discussions of trial strategy, which it allowed, and discussions of testimony, which it prohibited, but that's no line at all. It's often impossible to discuss trial strategy without discussing testimony. And responsible defense lawyers, worried about being held in contempt for crossing this invisible line, will be chilled from
not how it
offering
works
the
with judges,
assistance
Chris.
that the defendant needs and that the Sixth Amendment guarantees. The only conceivable rationale for restricting overnight discussion between defendant and counsel is to prevent impermissible coaching.
Can
But as
be
the court explained in
disbarred,
Getters,
but they're not going
there are
to
other
be
ways to
technically
prevent
removed.
coaching. There's no need to prohibit the defendant and counsel from discussing the defendant's testimony. I invite the court's questions.
It takes a lot
In
to
the
get somebody
judge's,
disbarred, just
instructions,
FYI.
He says, I don't want you discussing what you couldn't discuss with him if he was on the stand in front of the jury. What's wrong with that?
Because if he was on the stand in front of the jury, they wouldn't be allowed to
No,
discuss.
he's saying,
court
I don't want
testimony.
you discussing anything that you couldn't discuss involving his testimony before the jury. That's the standard for what's permitted and not permitted at that evening.
Okay, well, the trial court, if you read the entirety of the colloquy between the trial court and defense counsel, it's clear enough that the trial court prohibited all discussion of testimony, the defendant's testimony, during the overnight recess, and that is how the Texas Court of Criminal Appeals interpreted it. So the Court of Criminal Appeals interpreted I'm going to get the wording exactly right from the court's opinion. The Court of Criminal Appeals said, they described the question presented as, does a trial judge's sua sponte order that defense counsel could confer with defendant on everything except his ongoing testimony violate the defendant's Sixth Amendment?
So would it violate the defendant's Sixth Amendment right to counsel if during trial he was precluded from being coached or managed by his attorney?
You mean during an overnight recess?
No, during trial.
Oh, during trial. No,
What's
during
the
trial.
difference?
Under Perry, well, Perry drew a sharp line
why
between
it's a
overnight
legal
recesses
question,
and
Chris.
brief daytime recesses. And the court said that during a brief daytime recess, like I think you're talking about here.
No, what I'm talking about is, why is the standard different between what a lawyer can coach or manage with respect to testimony while he's on the stand, which is basically a concern, and what he can coach or manage during the recess.
No, it's the same. The distinction, let's be clear about the distinction between impermissible coaching and legitimate necessary counseling, right? Because that's a sharp line, and in answer to your question, that line is the same at all times during the proceeding. That is, whatever is impermissible before trial begins is also impermissible during an overnight recess. It's impermissible at any time, and let's talk about what that difference is, right? So the impermissible coaching is where the lawyer tries to get a witness, the defendant or any other witness, to testify, where the lawyer tries to change the substance of the witness's testimony.
To
try
suborn
to get the witness
perjury.
to testify to something other than that which the witness believes to be true. The court
Can't suborn perjury.
contrasts that
I'll be
with
right back.
conventional
2 seconds.
counseling, which is talking about the testimony in all other contexts. So, for example, advising how to comply with evidentiary rulings, even rehearsing the questions and answers.
But did any of that happen here? Do we have evidence that any of that happened?
It couldn't have happened. It didn't happen because the trial court barred the defense counsel from discussing Mr. Villarreal's testimony with him during the overnight recess.
Can I follow
Counsel,
up on?
if you, one of the things you say could protect against any problems with your approach.
Sorry, guys.
Looking at page 14 of your brief, you say that the
If
prosecutor
you are
could
coming in,
cross-examine the
thank you so
defendant
much.
after-
We're listening to
after the-
Villarreal versus
when the
Texas.
trial picks up again the next day. As to the extent of any coaching, isn't that a real problem with respect to the attorney-client privilege? What is the prosecutor going to say? Okay, you had a break, you spent the evening with counsel. What did you talk about? Objection, Your Honor. Attorney-client, I don't see how there could be a reasonable counterweight to the problems.
I understand what you're saying. The attorney-client privilege has never been understood to insulate a defendant or any witness from being cross-examined about the extent of impermissible coaching. So the dialogue would go, well, didn't your lawyer tell you to say that? No, he didn't. Or yes, he did, or something like that.
What did he tell you to say? You say, well, didn't your lawyer tell you to say that or whatever? And he says, no. He said, well, what did he tell you to say? Or what did he tell you to change?
The court in Getters said, and we're merely following that the way to deter impermissible coaching is for the prosecutor to cross-examine the defendant about it. Now, you're right that to say that functionally it seems like it might raise the same sorts of privilege problems as having the court ask it, but that's what the court said in Getters, and not just Getters.
Okay, but something I want to point out here is pre-testimony, right? Pre-testimony. Your attorney is going to talk to you about what you're going to be asked on the stand. Your attorney is going to discuss those matters with you. They're not coaching you per se, but they're going to talk to you about ways you would frame your answer, things like that. They can't suborn perjury, but they can also tell you, hey, maybe phrase the question or phrase the answer this way, things like that. Now, they're absolutely right that the prosecutor can come back and, cross-examine you. But like to say that a defendant can't talk during a recess to their attorney about their testimony, absolutely, I think fundamentally violates their right to counsel.
Thomas's point.
Apologies, guys.
The management of testimony, the talking with the witness about his answers and what some people would call coaching, prepping your witness, can occur beforehand, right?
That's right.
But it can't occur while the witness is on the stand. So Justice Thomas, I think, is pointing to a critical point, which is to the extent that the lawyer couldn't manage, coach, prep, practice with the witness while he's on the stand, why should he be allowed to do so during an overnight recess?
This is straight out of Perry. So the court in Perry said that during a brief daytime recess, the trial court can prevent all contact between the defendant and counsel.
I understand. I'm focusing
Yeah.
on the content of the.
Yeah, no, I understand.
Right.
But
So Perry doesn't help us with that.
No, yes, it does. I'm getting
Yeah.
to that, right? So the court said that after explaining all of that for a brief daytime recess, the court then in the next section, section 3 of Perry, the court says, well, overnight recesses are completely different. The court says, admittedly, the line between the facts of Getters, that's an overnight recess, and the facts of this case is a thin one. It is, however, a line of constitutional dimension. The court goes on to say during an overnight recess, it is the defendant's right to unrestricted access to his lawyer for advice on a variety of trial-related matters that's controlling. And then here's the key sentence: the fact that
It's
such
Villarreal
discussions
versus
will
Texas.
inevitably
Villarreal
include
was
some
convicted of
consideration
murder
the
in
defendant's
Texas.
ongoing testimony does not compromise.
Right.
that
So
basic
that's
right.
precisely what I'm getting at.
Yeah.
I think there might be, and
So if I'm remembering this correctly, Perry is a question of if there is like a 15-minute recess. Getters is a question of an overnight one. That's so just so everybody knows.
I want you to help me with this.
Yeah.
A difference between discussions that take into account the testimony, maybe even the fact of the testimony.
Let me
and
look up
something
Perry
that
real quick. I
one
think
could
that's the
call
one I'm
managing or
remembering.
prepping
Right.
or the kind of thing that you have even admitted a lawyer does
Right.
legitimately to help his client before he takes the
Right.
stand. And what I understood the trial court here to be doing was just eliminating that very narrow category of conduct that a lawyer engages in to actually prepare his witness with respect to particular questions and answers on
And,
the
that,
stand.
and that's the line the Court of Criminal Appeals tried to draw, right, between discussion of what you're calling
Yeah.
prepping
Okay, I was
testimony and discussion of testimony in other contexts.
And why are they wrong about that?
Because that line just, I mean, to even call it a line is wrong. It's not a line, it's a Rorschach plot.
But
right?
that's the line that Perry drew. I mean, if you go up a few sentences from the sentence that you read, the court says, an overnight recess is different. Why is it different? Because an overnight recess will go to matters that go beyond the content of the defendant's own testimony, matters that the defendant does have a constitutional right to discuss with his lawyer, suggesting that as to only the defendant's own testimony, the defendant does not have a constitutional right to discuss with his lawyer. Now then, it talks about how, of course, when you talk about the protected matters, there might be some incidental discussion of the testimony itself. So it concedes that perfectly willingly, but it draws a pretty sharp line between matters going to trial strategy and matters going to trial testimony of the defendant itself, and says that that's
Thank
the
you,
reason
everybody.
why the recess, the overnight recess versus 15-minute recess
Thanks, Rudy.
makes a difference.
And like I said, that's no line at all. And the way you can...
But that's Perry's line. I mean,
But no, I don't know.
It might be that Perry was wrong, but that's Perry's line.
No, I disagree. Perry goes on to say that a defendant has an unrestricted right of access to his lawyer during an overnight recess, including for consideration of the defendant's testimony. So let me get, so it's you're trying to draw the same line that the Court of Criminal Appeals drew.
Yeah, I'm not trying to draw it. I'm suggesting that Perry says it right here on page 284.
Yeah.
That's the key language from Perry. Now, Perry goes on to say, as I think your friend in Texas goes on to say, that there can be all kinds of places where the testimony has to be talked about as incidental to what is protected, which is the discussion of trial strategy, but not in and of itself.
Okay, first of all, I disagree respectfully with your view of what Perry held, but if Perry held that, I think it's just incorrect, right? So let's work through some examples. That's
on page 285. That's a concurring,
the defendant
or
has
that's
come
something
very-
other
an
than the
unsophisticated
opinion of the
defendant
court.
has come very close to mentioning excluded evidence that would be absolutely devastating. During the overnight recess, defense counsel needs to say to the defendant, "Look, you nearly mentioned
Y'all
this,
can just
this,
tap
this
the
evidence."
screen for me. I would so so
resume again
appreciate
tomorrow.
it.
You better
Thank you
remember
so
not to
much.
mention that because we're going to be in big trouble if you mention that tomorrow. Okay, is that consideration or is that discussion? Is
Mr.
that
Benner,
direct or indirect?
And thank you so much to
maybe I'm
everybody
missing
for the
something, but I would
support.
think that would be permissible because it doesn't refer to the testimony itself. It can simply be a reminder, hey, don't go here. That might implicate.
No, but it does refer.
If I might finish.
Oh, sorry.
I think what my colleagues are getting at, and what I kind of thought you even conceded in your brief, is that coaching, and maybe we were defining coaching differently, perhaps that's it, but that there are some things that a district court can constitutionally prohibit counsel from doing. And while a witness is on the stand, even if there's a recess, you agree with that, right? You think there are some things that can be prevented?
Absolutely. Coaching in the sense of suborning perjury, altering the substance.
Suborning perjury.
I'm not talking about suborning perjury. I'm
No.
talking about coaching.
Well, but
All right,
we know
if you don't like that word, let's use management, okay? Which is the word Texas uses.
I like that word even less.
Okay.
Yeah.
What in the Constitution?
A lawyer's
what in history
entire job
suggests that you have a right
is to make sure that a defense attorney is to
during
make
the
sure
break,
that the state
as
proves their
opposed to
case
derivative
beyond a
or
reasonable
collateral
doubt,
matters that you
and
do
also
advise
to
about. There's a plea
instruct
agreement.
their
The way things
clients.
gone today, maybe we got to take that plea.
It's what they do.
But there's some excluded evidence. Be careful not to step into that. I can see all of those kinds of comments, but I'm having a hard time understanding historically, traditionally, what have you got that says that there's a right of a witness to be coached, or if you don't like that word, managed by his attorney while he's not on the stand, whatever the length of it.
Yeah. So let's talk about the history. So that the precise question presented in this case could not have arisen at the founding because defendants weren't allowed to testify until the late 19th
Obviously.
century. Right. And so the question is, what's the appropriate inference to be drawn from historical practice? Right?
And historical practice is that once you become a witness, you are generally subject to the rule that you can't talk about your testimony. And that's generally understood to mean coaching and managing, but not advice about other legal matters. That's my understanding of the truth.
I've got 3 points I'd like to make about the history. Okay. First of all, it's crystal clear at the founding and all the way till now that while the defendant, there are times when a defendant can certainly be denied access to counsel. When he does have access to counsel, he has a right to whatever assistance, including discussion of testimony, will be useful to him. Right. So there's certainly historical warrant, as the government points out. Both governments point out there's certainly historical warrant for saying that there are times when a defendant lacks access to counsel. So, in a prison in the middle of the night or something like that, sure. But there's no historical warrant for saying that when a defendant does have access to counsel, the trial court can say, well, you can talk about topic A, but you can't talk about topic B.
Would your rule apply to witnesses who have counsel?
No, because non-party witnesses, they don't have a Sixth Amendment right that a defendant has. This is a rule specific to the defendant.
They have a right
That's
to counsel.
big here.
And they brought counsel.
During a criminal right to counsel.
Would it apply as well in civil proceedings to the defendant there?
No. The trial court can sequester non-party witnesses. This case isn't about that. This case is about the defendant as a witness.
In civil proceedings where there's a right to counsel, presumably? Yeah, it apply there.
I don't know. I mean,
It's just that there's a long historical tradition of witnesses going on the stand being told something like what the trial court said.
Non-defendant witnesses.
So, Mr. Benner, can I just clarify? You're entirely rejecting the line that Justice Kagan drew to your attention, and you're saying that even during the day, let's say it was an hour, you're saying this is all about time. So even if the recess was for an hour for lunch, you are saying that the district judge cannot restrict what the counsel and the client, the defendant, can discuss.
No. So again, this is Perry. Perry says that during a brief daytime recess, the court can.
Real quickly, so they're not making the argument to be able to coach a witness during a recess. They're making the argument that restricting what you can and cannot talk to your client about during a recess fundamentally your defendant, sorry, let me be specific, fundamentally violates their Sixth Amendment right to an attorney.
Hard cases between 15 minutes in Perry and overnight in Getters. I have to say, in practice, the lower courts have had no trouble drawing this line. Daytime recesses are usually pretty short. Overnight recesses are much, much longer. It's very easy to tell, to draw that line. Now, in theory, if a court were to say, look, we're going to have a recess from 9 a.m. to 5 p.m. and we're going to be like a vampire court and just do it at night, maybe.
Okay, so your rule then is that any time during the day when there is a recess, the district court could, subject to maybe some extreme case where it goes on for too long and you have a vampire court, the court could say, you can talk to your lawyer about everything except the lawyer cannot manage your testimony during the day.
Again,
During the day.
During the day, again, because the greater includes the lesser.
Right. And you can't do that at night.
Correct, because at night.
It's unrestricted because Getters says that. So there's no, you can't have a line at night.
This is a bad argument.
You can have a line during the day, but not at night, right?
I wouldn't have drawn that line.
Getters says that, but Getters was correct in saying that, right? Getters pointed out correctly that overnight recesses have always been times of intense strategizing, discussion, and so on. And whereas Perry said, well, not so for brief daytime recesses. Let me, if I could.
Mr. Bannock, can I ask you a concrete question? I mean, I can read Getters and Perry, but I'd like an answer to a concrete question. And let me give you an example. Let's suppose that a very important issue in a case is the meaning of Exhibit A. And in preparing the witness to testify, defense counsel goes over what the witness is going to say about Exhibit A. Doesn't put words in his mouth, but you know how it's done. So it's all prepared, a way of dealing effectively from the defense standpoint with Exhibit A. Then when the witness gets on the stand and is under cross-examination, the witness departs from that and says things that are quite damaging.
They always do that.
During a recess, overnight, or during the day, well, let's just say overnight, can defense counsel talk to the witness about that and say, look, the understanding was you were going to say this, but you said something different. This is very damaging. That's allowed?
No, because that's a third party.
The defense counsel can say, look, when we rehearsed this ahead of time, you were going to say A, B, and C. Right. But instead, you've said something totally different, which is D. Now, you've got to tell me which of these is actually correct. Because if you said D accidentally, then tomorrow we need to correct that in question.
The next day when the defendant takes the stand, everything is cleared up. Now he's back to, it's a sea change, back to what was rehearsed in your words before trial. Can the prosecutor on cross-examination say, well, you said this yesterday, now you say this today?
Yes.
Did you talk to your lawyer last night? Yes. How long did you talk to your lawyer? Did you talk about this? Can he ask whether they talked about that issue?
Well,
is that a violation of the attorney-client privilege?
I don't think so.
To ask them?
Because
no.
As the court's held several times, the proper way to ferret out any impermissible coaching is cross-examination, and then the prosecutor arguing to the jury, look, this witness is not credible because this witness was
to ask them if they talk to their attorney, no, but
had to do with
asking what they discussed about problematic.
About important matters, but you think the prosecutor can go into that?
Well, I mean, honestly, I'm honestly not sure. And maybe you're right. I honestly don't.
Well, it matters a lot because you're saying cross-examination is the corrective. All right. Suppose we've got a lunch break, 1 hour break for lunch. Two absolutely identical defendants. Both, Exhibit A is important for both. In one, there's a lunch break, and one, there's an overnight break. Does the same rule apply in those two situations?
So
Exactly. That's why nobody would
right
ask
to
it to be.
Well, don't tell me what the cases say. Just tell me why it would make sense to have a different rule.
Because you're right. I was about to do that. You're right to suggest that there are times when a well-timed overnight recess can be an advantage to a defendant that another defendant who doesn't get an overnight recess wouldn't have. That's absolutely right. But that is a result that is required by the Sixth Amendment because the alternative would be much, much worse.
Well, my question, I want to get to that, but my question has to do with a lunch break or a 15-minute break during the trial versus an overnight.
Right, that's what I'm saying.
Same
different
rule.
Different results.
Different rule.
Different
Why?
results.
Why?
Right. Well, two reasons, right? One is that's what Perry said. We're just repeating the holding of Perry.
I don't know
you want to
yet.
overrule Perry? I'm not going to complain, but that was the holding of Perry. But second, that it makes sense because, as the court said in Getters, overnight recesses have always been times of strategizing, discussions. This is the time when this is like prime time for in the middle of a trial is an overnight recess.
Yeah, if the defendant is on the ropes during cross-examination, an overnight recess can be very beneficial.
Very beneficial.
Once again, I'll continue this.
Well, can I just finish the answer?
Well, I didn't get the
You didn't get-
question
okay.
out. I'll get to it. I'll be back.
You gotta shut the fuck up when they start asking questions.
Okay, once again, two absolutely identical defendants, two trials. 5 o'clock, the defendant is on the ropes in cross-examination. 5 o'clock rolls around. It would be really helpful for this defendant to have a break and and regroup. So the judge says, well, you know what, how much longer is cross-examination going to be? The prosecutor says 3 hours. So the judge says to the defendant, well, you know what, we can go on until 8 o'clock, or we can take an overnight break, subject to the restriction that you can't talk about the substance of the testimony. What happens then?
Well, your latter alternative would violate the Sixth Amendment. During an overnight recess, you have a right to talk about your testimony with counsel. That's super, super important.
So a different result in those two
situations. It's the distinction between a daytime recess and an overnight recess.
But the question would be, why can you do it overnight and not during a mid-break recess? That's why I thought it was a bad argument for this attorney to make.
Coaching is where the lawyer tries to change the substance.
Why is there an arbitrary line there?
So you said before that in our just talking ahead of time, you said that the light was green. No, you should say that it was red because that's more helpful.
It may be Gorsuch. I'm bad with the voices. I can pick out like Sotomayor and Barrett. Otherwise, I'm like,
this is what you should say.
Right.
But when you're preparing a witness, I mean, you could do the same thing overnight to get the witness to remember.
Oh, and Kagan, I can use, and Jackson.
Well, look,
all the women basically.
The other side. So what I just said was impermissible coaching. Conventional
Men all sound the same.
is where the lawyer says, "Okay, I'm going to ask you this question. What's your answer going to be?" The witness rather gives the answer. Lawyer says, "Look,
oh yeah,
that's a
Thomas
big jumble.
says yeah. Sorry,
why don't you
one.
say it like this without just suggesting words without changing?
Right, thank you very much.
Okay.
Ms. Sotomayor? Am I correct to say that you say the only order a district court can give overnight is basically the ABA rule? A lawyer can only be prohibited from telling the defendant to give false testimony, correct? That's your definition.
Well, I mean, I would say.
Counsel, just answer yes or no.
Well, okay, mostly yes.
Okay.
Mostly.
So assume, please, and don't fight me, that I think that Texas's position is more nuanced. And I accept that improper coaching that could be prohibited.
But what is improper coaching? Like they've not
questions and answers
centered that.
Telling a defendant
you can't suborn perjury, but improper coaching.
Another word, what generally is thought of coaching. But Texas, and I think Justice Kagan defined their position, they can discuss incidental
it's
effects
a huge range, Cubs,
of testimony. And that would include, and pay attention to the list, plea bargaining, including telling a defendant that they did lousy and they should take the plea, perjury, you lied and you shouldn't, excluded evidence, the one that you were worried about, other witnesses and where they might be located, contact information.
Agreed, MJ.
What else? What is missing from that list? Assuming the first bucket.
Yeah. So what,
You can't coach, you
I
can't
agree,
give questions
Cubs.
and answers, you can't
It's just, this is a really
tell them to
odd
use a
thing.
particular word or change a word, even if it's not perjury.
Okay.
Assume all of that. What's missing from that list? What other thing is missing?
Well, that list covers many of the most important.
I just said.
But what it doesn't include is what you specifically excluded at the start, which is going over questions and
All right, so if I say no to that, but say yes to the incidental effect, there's no other topic that you can imagine?
You know, off the top of my head, I'm sure there are others. I mean, a defendant and counsel
So
have a million things.
wouldn't the definition that Texas provides, which is the incidental effects of testimony, is okay?
That's no line at all. How is anyone
Assuming
supposed to?
I believe there is the workability issue, there's no other topic you can think of.
Well, if you gave me a little time, I could probably think of more because there's an infinite number
Now,
of things.
going back to Justice Thomas's question, there's no facts in this record that would suggest that the defendant wanted to talk about plea bargaining, or the counsel wanted to talk about a missing witness, wanted to talk about perjury. There's nothing in this record to suggest any of that, correct?
That's correct, but the reason is that defense counsel understood the court to be barring all discussion of testimony, period, and the court confirmed that.
Counsel said, Judge, I understand what you're saying. I won't manage the testimony.
No, there's more. So the colloquy here is at pages 4 and 5 of the blue brief, right? So the court says, what you can't discuss is, this is the second to last paragraph on page 4. The court says the thing that you can't discuss is, at the very start of that paragraph, his testimony. And if you look at the top of page 5, defense counsel says, we aren't going to talk to him about the facts that he testified about. The court says, all right, fair enough, right? So the reason why there's
We can read the transcript.
Okay.
Thank you, counsel.
Okay.
Justice Kagan?
This isn't
Banner,
probably
with
the
respect, you
attorney I
have
would
had a
have
little bit of
picked.
time
I think
since
he's
Texas
kind of
is brief.
making a bad
And
split
Texas,
argument.
as I think you say in your reply brief, you say, well, Texas has narrowed the conflict a great deal and does come up with this set of examples of how discussion of trial testimony would be relevant to matters of trial strategy, and so could proceed during a recess. And it seems to me, like, unless you can tell me what other things there are like that, the Texas is basically saying anything that's relevant to larger matters of trial strategy, that should go in one bucket. But if all you're doing is going over the testimony, he said this, you said this, you might sort of think about adding this. He said
Kagan.
this, but you explained it to me a little bit better when we rehearsed this. If is that what you're holding out for, to include that as well? Is that the only thing that stands as a difference between you and Texas right now? I'm not sure, honestly not sure if it's the only thing, but it's a more important thing than you're suggesting because it's a common situation. So defendant says something completely surprising, something different from what counsel thought that the defendant was going to say. Overnight, they need to be able to say, oh, wait a second. When we talked before, you said A, B, and C, but now you're saying D, E, and F. Why is that? That's
Cubs,
that
I
is crucial for the
1000%
assistance
agree
of
with
counsel.
that.
It could be
He needs to have a
necessary
clear
to
and
prevent
concise
perjury. At the very
argument,
least, it's
and he
that's
keeps kind
covered
of
by Texas.
waffling, and it's not doing him any
I
favors.
understood your question to exclude. You need to be able to talk
I
about
think what I'm
something.
suggesting is that the only difference between you and Texas right now is, like, let's go over the trial testimony and see if we can do it a little bit better.
Yeah. So. Well, let me put it this way. Our view is that you just have a right to talk about your testimony, period, right? Texas's view, as I understand it, is that the Sixth Amendment protects this list of 11 things you can talk about, but not this other list of 7 things that you can't talk about.
I don't think that's fair. I think what Texas is saying, and Texas can correct me if I'm wrong, but it's pretty clear, which is that if the trial testimony comes up because it's relevant to trial strategy decisions, like whether to take a plea bargain, like whether to go find another alibi witness.
It was not that clear. I read the briefs. It was not as clear as they're making it.
You're allowed to talk about it, but it has to be incidental in that way.
I disagree with them here. It was not that clear.
It can't just be, oh my gosh, you didn't do that very well. Could we try to do it better? Thanks.
But that is a trial strategy decision. That is how we're going to present.
Like I read the cert petition, and they have a lot of that, and I read it was not that clear.
I think that's right. I think it's a smaller difference than it used to be. That's right.
Thank you.
Justice Gorsuch. Justice Kavanaugh.
I'm trying to figure out the logic of a line based on a 15-minute recess versus a lunchtime recess versus a lunchtime plus another matter I have to handle, so it's going to be a 2-hour break.
Kavanaugh for the win.
An overnight recess.
Well, the court in Perry said it's a thin line, but it's a line of constitutional dimension. If you're asking me to...
Where does that come from?
Well,
so 2 things. Where does it come from?
There should be no line.
And what's the logic?
Okay.
Because it strikes me
should have made an argument full forward or just not done it.
Let's talk about the logic first, right? So the Sixth Amendment guarantees the defendant a right to the assistance of counsel, right? Which should mean at the very least that if the government wants to limit the assistance of counsel, the government better have a very good reason for doing so.
You think?
Okay? And as I understand the logic of
I'm
Perry,
with Kavanaugh. Go all in.
It's in large part a
the
concern
entire
with
thing
trial
should have been
management.
challenged.
If defendants
I mean,
had the right
for
to
the level of
confer with counsel
specification,
during
obviously
every
this
little recess,
applies.
1
but
minute, 10 seconds.
the entire
or whatever,
thing should have been
It would just be
challenged.
impossible to run a trial. So there has to be some. I think
Lawyers know the rules
holding
for
Perry, there has
themselves.
to be some.
They know they can't
some
suborn
line where
perjury.
recess
They know.
is just too short.
And I don't think they're risking their law
where does
license
the
for some
opposite
asshole.
part of that rule, Where does it come from? The opposite.
And it all depends on as a question Justice Blackmun asked in the argument in Getters, it depends on the accident of a recess, which is a very, and then, the next page said you can't force a recess. So the whole thing is treating 2 classes of defendants very differently. And this might be critical to the outcome of the trial. If the trial judge does a recess, you're golden, or at least a long enough recess.
An overnight recess.
Overnight recess.
Yeah.
Long enough recess overnight. But if not, Perry says no. And so those defendants are going to be treated much differently. And does that make a lot of sense?
I think it does, because as the court said in Getters, an overnight recess
picked this
has
attorney?
traditionally been a time of intense discussion and strategizing. And
This is a
the shorter
horrible
you go
argument.
in a recess, the less true that is until you get to 15
If your Sixth Amendment is fucked while you're on the defense stand, blame fucking
I
this
understand Perry
chud.
as really the government needs a very strong reason to override the right to the assistance of counsel, and I read Perry as basically that reason being just the logistics of trial management.
But this dingleberry arguing for Villarreal is the worst.
I guess I don't understand your Sixth Amendment argument with respect to the defendant's ability to get that kind of management from his counsel during trial. So is it your position that a defendant has a constitutional right to consult with his attorney about the answers that he's given, turn to the judge and say, I'd like to have a moment to talk to my counsel while he's testifying?
No, of course not. There's no right to call a timeout
That's
during
not how that works.
Why not?
Well, I mean, a trial could barely go on if
so just pure logistics is what?
Trial logistics, I think so, right? Whereas
Agreed.
the concern with trial logistics is it vanishes during an overnight recess when everyone's got plenty of time.
But Perry suggests that when we have a 15-minute recess already planned and it's there.
God, I didn't get the name of the attorney, but this has to be the first time they've ever been before the Supreme Court.
Kind of management
you shut the fuck up when they
time.
open their mouth.
In fact, Perry says that's all that would be expected during that time, and that's precisely why we don't allow it. So I just don't understand. I don't understand your thought that the lawyer has the right, when his client is testifying, to talk to him about his questions and answers and coach him as to how to better answer the question.
Okay. I'm gonna quarrel twice with the framing of your question. First, he never doesn't have a right to coach him in the sense of impermissible coaching. He has a right to give advice about the wording of his testimony, not the right.
But just not during the trial while he's on the stand. But he can do that in a 15-minute recess.
No, he can't do it.
Why? What difference does the time make if he has the right to coach him in that way? What difference does the fact that it's 15 minutes versus overnight? If the Constitution says that a defendant has a right to be counseled with respect to his answers while he's testifying, I don't understand what difference it makes that we have a recess or not or whatever.
Well, okay, so but it's a distinction between a daytime and an overnight recess. That's the distinction the court drew in Perry. And like I said, if you want to ask me to justify that distinction, I think it's mostly just a matter of trial management. Because you think about it, if you say you have a right to counsel, to confer with counsel during a 15-minute recess, you can see the obvious questions: 5-minute recess, 1-minute recess, and so on. And so I think the court just said, look, at some point a recess is just too short.
Thank you.
Thank you, counsel. Mr. Worthen?
Mr. Chief Justice, and may it please the court. When the defendant's testimony is paused for a long break, the trial court may tell defense counsel not to either manage the ongoing testimony as we propose or not to discuss the testimony altogether as the United States proposes. Both rules are supported by this court's precedents. In Getters versus United States, this court barred absolute no conformal orders during long breaks, but it never opined on qualified orders. Indeed, Getters himself would have been fine with such an order. In Perry versus Leak, this court allowed both absolute and qualified orders during short breaks, emphasizing the importance of untainted cross-examination to uncovering the truth. Perry reconciled its holding with Getters by noting that there is a constitutional difference between discussing ongoing testimony, which is not protected, and discussing other trial-related matters, which is protected. And as long as protected matters can be discussed, the right to counsel is preserved. Moreover, by allowing qualified orders, Perry necessarily recognized that counsel can indeed navigate such orders during short breaks, and there is no logical reason why they could not do so during long breaks as well. Accordingly, qualified orders allow trial courts to balance what the Constitution actually protects with the integrity of trial, and that's exactly what happened here. I welcome the court's questions.
After the night passed and there was no, you had testimony by petitioner, was there some objection to the judge's order in the sense that petitioner said or his lawyer said that they were not allowed to discuss matters other than testimony?
Not at all, Your Honor. When they came back the next day, the trial court asked them if there was anything to bring up.
I heard Roberts a little earlier, at least I think it was him.
Your Honor, and they never filed a motion for a new trial. In fact, not only that, on top of that, my friends on the other side, they say the only way to enforce these orders is to say, well, what did you talk about last night? But that didn't even happen. The trial court just started his testimony up the next day.
Thank you.
And everybody went on. It was assumed that they followed the court's order.
Mr. Worthen,
the state of Texas and Villarreal versus Texas right now.
Position as compared to the Solicitor General's more absolute rule. And I just have a couple of questions about that distinction.
Sure.
First, is there any reason why the court needs to reach the Solicitor General's more absolute rule in this case?
The only reason you would have to do that, Your Honor, is if you read the order actually given in this case more broadly.
I think that's right. That would be the only reason why we'd have to reach the government's position. You agree with that?
Yes.
Okay.
If you read it the way we read it, it would only be a managing order, a no managing order, not a no testimony.
No, Texas Court of Criminal Appeals is the highest level of criminal
where the court says
courts here in Texas. Our Supreme Court is only civil.
Well, actually, what we said in Perry, that an overnight recess that would encompass matters that go
I know,
beyond
right,
the
Cubs?
content
Like,
of
they need to get
defendant's
some
own testimony.
cameras in there.
Matters the defendant does have a constitutional right. Those are protected. If we understand the trial court's order in this case to be consistent with that standard, is there any reason why we need to address the Solicitor General's proposal?
No, I don't believe so. If you believe it's just if this is a small, like, I guess you can conceptualize like this. If this is broad, this is a narrower
I
kind of order.
appreciate everybody coming
best
in.
reason
We're
why
listening
that's
to
the case
Villarreal
here.
versus
That
Texas.
this is a narrow order?
Yeah.
Well, so if you look at page 7A of the appendix,
Look up. It'll
he
tell you what they're
says, I
talking
don't want
about.
you to discussing what you couldn't discuss with him if he was on the stand in front of the jury, his testimony. I'm not sure whatever else you would like to talk to him about when he's on the stand, but ask yourself before you talk to him about something, is this something that manages testimony in front of the jury? And I think what he's saying here is the only thing you'd want to do while he's on the stand testifying is go up there and say, you need to slow down, you need to stop shifting, you need to look at the jury in the eye, you need to remember the things that we talked about as far as the things you should say. Here are the questions I'm going to ask you next. That's all managing of the way we
TikTok
define it.
glitch then.
And then he tells him, just ask yourself when you're talking to him tonight, you can talk to him about something, and even gives an example of potentially if they go into a punishment phase, you talked about something, but if you're going to be managing his testimony, you can't do that.
And as Justice Thomas pointed out, there were no questions or follow-up clarification requests from counsel.
I will say, I read through some of it.
Clarification on his own after
It
that,
wasn't this
but there was no
specified.
question about. Can
It
we talk
was
about perjury?
broader
If
than
that-
they're
if that's maybe a
allowing
thing,
for.
Can we talk about potential plea bargaining? They didn't ask any of that.
Thank you, Mr. Ward.
Counsel, let's say the defendant and the lawyer go into their, wherever for the evening recess, and the
How are you going to have your
defendant says
ass
something
cheeks as a
like,
profile picture?
Counsel, you remember when we were preparing for this, we both agreed we should
That's
try to get
brave.
the jury to focus on Fred. And whenever it's reasonable, I should mention Fred.
Attorneys
And
for
I've been doing that.
Petitioner
And I notice
Stuart
every time
Banner.
I do that,
Nobody hires
juror
Stuart
number 8 gets
Banner.
a big frown and shakes his head. He doesn't look to me like he likes the idea of
Thanks,
talking about
Davina.
Fred
I
at all.
appreciate
So
you.
I think that's a bad idea. Now, talking about Fred was your idea. Do you still think it's a good idea? Can the lawyer respond to that question?
No, they would have to tell them I'm under a court order not to answer
So at that point, he tells the defendant who's facing a capital sentence, I'm not going to tell you. It's a very simple thing. Don't talk about, he's not saying particular things, but let's stop talking about Fred whenever we can.
Yes, that would be managing his testimony. That would be coaching and strategizing with him.
Counsel,
Do you think that the,
no, go ahead.
do you think that counsel can say, listen, I've been noticing that you've been mumbling, and you're also not making...
So since this is the state of Texas and I already know how this case is going to play out, I'm going to make a point for all of you that I think you should hear. The predominant amount of judges have not done a lot of time as defense attorneys. They generally come from a prosecutorial background. So I want you all to think about whether that factors into the way that they assess a case. Just think about that hypothetically.
Sure that that you're still saying what you're saying on page 14, where you say direct discussion, i.e. testimonial management, that is direct discussion of the testimony, can be prohibited. So whether it's the Chief Justice's question or my mumbling question,
I agree,
that's
Esteban.
direct discussion. But counsel can still discuss a range of issues related to the testimony, including calling additional witnesses, plea bargains, legal objections, court orders, excluded evidence, and the implications of perjury, among others. So
Yes.
that's still the line that you're drawing.
Yes, the touchstone is always the lawyer should contemplate for a moment and ask themselves, is this going to cause me to manage their testimony? The way we define
They're
that is coaching,
discussing-
grouping,
look up
strategizing
here.
about the testimony itself. Not
Sorry,
about other
Aaron.
things related to the you could strategize all you want about, should we still bring in the expert witness?
Sotomayor is
things like
still
that.
over
But as
here
far as
simping
how
for the state
testimony
of
is ongoing,
Texas.
that
Don't
would not be
play.
And when Mr. Banner says that's not a line at all, what is your response to that?
No, I think that's a very real line because, I mean, one, the case law draws that line. And I think
Well,
the
I
logic
think
of Perry
the-
is very strong.
Lawless, I
They say
think
it's an empirical
hypothetically
predicate of our system
treating
of
a
justice that
defense
an
attorney
uncounseled,
like
witness
they would
is more
commit
likely
a
to tell the truth
act
than
that
one who
could
has time to
disbar
pause
them,
and consult with
remove
their
their
attorney.
license, or potentially
And
be a
they
crime
say
is
this
super
rule applies for
problematic.
both witnesses generally and defendant witnesses. They don't draw a distinction between the two. And I think there's a lot of logic to that, because if that wasn't logical, then we would have to get rid of this rule for all witnesses. I mean, all witnesses would have to be, let's say this, that we flip it around. Let's just say it's the state
Doesn't have
star
to get rid of
witness. So
all
let's say the
witnesses.
victim had
This
lived in
is
this case and it was an
specific
aggravated
to a
assault case.
defendant.
Why wouldn't the state be able to talk to the witness overnight and coach their testimony if the victim is not doing very well on the stand? The same logic would apply the other way.
Thank you.
Counsel, I think I might have missed the answer. The question was like, can you tell the witness to stop mumbling? You said he can't say that?
No, I would consider how you present yourself to the jury. I consider that to be also coaching, a form of coaching. Look at them in the eye, stop mumbling, don't talk as quickly, things of that nature.
What's the exact formulation, if you have one, of what
I
the
don't
judge
disagree,
should
Esteban.
say to the counsel before an overnight recess?
Well, I would say something like this: if for a managing order or a testimony generally. Managing order, I was if I were the judge, I would say.
Oh, let me make you a
I'm not
mod.
going to go through an entire list of everything you can talk about. Whenever you're sitting there talking to your client, I want you to ask yourself, is this directly talking about the testimony, or is this conceptually, is this something that's a derivative matter from it? And in any event, regardless of what you're talking about, does this require you to coach, regroup, or strategize about the testimony itself?
Don't you think lawyers are going to have very different answers to that questions when they ask themselves that question? Yeah, I guess the point being, is that line really able to be applied in a neutral and equal manner?
They might have some differences of opinion, but we do trust lawyers to use their judgment whenever they are complying with any kind of
you
court
trust
order.
lawyers
And our
only
rule
they
also
can't confer
allows,
with their
any
clients.
lawyer, if they're just not
Cool.
sure and they really don't want to run afoul of the court's order, to come back and ask the trial court and to say, Your Honor, I wasn't sure about this. Can I get some clarification or even maybe some reconsideration?
Sorry, guys, I'm trying to set a
let's say it's like
mod.
5 a.m. or something like that, and they don't want to bother the trial court judge at 5 a.m. They can wait till the
Apologize if
morning.
I'm looking at you
and they can
crazy.
explain the problem that they were having, and then they can ask for a
So
continuance.
that's important. That's your solution to ambiguity for the
Sorry.
lawyers, is just come back and ask if there's something you want to talk about.
That's right.
Counsel, let me ask you about the government's, the Solicitor General's position, which we've now established is much broader. It's a no testimony order. What are your thoughts on the workability of that? I mean, the counsel on the other side suggests that there are all kinds of discussions that involve trial strategy that are going to be related to the defendant's.
So all of this line of questioning is absolutely ridiculous. The supposing that a third party witness, because they have an attorney, the Sixth Amendment specifically relates to a defendant, right? Okay, so first of all. Second of all, the other lawyer's argument was absolutely crazy because he said it's okay during a 15-minute recess, just not an overnight one. No consistency whatsoever in any of this bullshittery.
About which is the substance of the ongoing testimony.
Counsel,
Lord. First one of the season, guys.
Justice Gorsuch asked.
Straight out the
facts
gate,
of
this cray-cray.
case are really your position in this case, which is the judge
Had a long time to prepare.
Management. But the SG wants us to announce a bigger rule.
Thank you, everybody coming in.
That rule?
Their rule would, you're asking if I agree with that. I think it would be supported by the case law, yes.
All right. How would it be supported by logic? Putting aside, you agree that under any circumstance, a
So
lawyer
he
has an
was,
obligation,
but he was
even we've
specified
said it
that he
admits,
could not talk about the
to
contents
not
of the
suborn
testimony.
perjury. If a
Despite
client is suborning
SCOTUS
is
interpretation, I
perjuring
actually
him or
read
herself,
it. It was rather
the lawyer just
broad
can't sit
in what
there
he couldn't talk about.
and not do something
And
about that.
they were
So,
like, well, you should have
that's the close
assumed
case
it was
here.
a whole
What
thing,
can
but
they do?
yeah, it's
You
kind
would
of,
say
it's
They can
bullshit.
say to the defendant, if you commit perjury, these are the consequences, correct?
Yes.
If the government says no, that's really dangerous. How about plea bargaining?
Oh,
The
I will be
government
live
said no
tomorrow
to
as well,
to
Davina,
say
for
your testimony is
what is
really
it?
bad.
It's Chiles versus
You should
Salazar.
reconsider taking
I'll be
this.
live for that as well.
If the lawyer doesn't do that, he or she is not supporting their ethical obligation to give the defendant information.
Yeah, I gotta
adequate
read the
information to consider a
cert
plea,
petition
correct?
tonight. Thanks.
Well, I think in order to comply with court orders, you are able to
excuse the ethical obligation.
Well, yes, to a certain extent. I would be
But
surprised.
putting that aside, at what point do we accept the SG's position? Because an order that says don't talk to the person at all, we said in Getters, in Perry, was wrong. I'm sorry, in Getters, we said don't talk to the defendant at all.
That's correct. And
So the question is where to draw the line. Should we ignore that line here?
Well, I think in Perry, they drew the line at between testimony and not testimony. I mean, they even go so far in Perry as to say you can tell them not to talk at all because we're so worried that you're going to go talk to them about their testimony.
Right, but we said in Getters you can't do it overnight.
They say over, that was the context of that. I would say they'd say a long break, but the problem with, as was brought up earlier, drawing the temporal line between the two is a problem.
Makes no sense, so I don't. I do between what you can talk about and what you can't.
Yeah. Yes.
Thank you.
I'm sorry.
So again, this presumes that a defense attorney would be unethical.
Instruction, and tell me if you agree with it or if you see any kind of difference between your
That's
position
highly
and what I'm going to say and
problematic.
what the SG says.
A
What if the
client
court
potentially,
says, or what if
an
we were to say
attorney,
that qualified conferral orders are okay if they tell the lawyer, listen, you can't talk about the content of the testimony or the manner of its delivery, but you can discuss any strategic consequences of the defendant's testimony, such as whether to take a plea, whether to call another witness, etc. Are you okay with that?
Yes.
Okay.
What?
Ask the SG whether the SG thinks that's consistent too.
Mr. Worthen, I just wanted to quickly follow up on Justice Sotomayor's line of questioning. And I wonder whether unconstitutional conditions doctrine might be in play. If you were to say that a lawyer couldn't advise a defendant during
That's
a
a
long break.
primary
about
backbone
collateral
of the
consequences from
system, Wallace.
if I can't advise you, boy, it's time
Ethics
to
are
take that plea.
fundamental.
If I can't tell you about the consequences of perjury, maybe I'm excused as an ethical matter because I'm under a court order, perhaps. But I would have thought that our
Attorneys
unconstitutional
know they
conditions
cannot
doctrine would
suborn
have something to
perjury.
say about
Like,
unnecessarily chilling.
I don't know
the
why
Sixth
it's
Amendment right to
presumptive that a
speak.
defense attorney would
Now,
do
are
this,
you asking
but
from
they
the
don't
management
have the
perspective or
same
the SG's?
The SG's perspective.
preconceived notion about a prosecutor.
Unconstitutional conditions doctrine.
I don't want to put words in your mouth, but I think the SG
They put
would
people on the
say
stand
that
as
there's
well.
two ways to go about dealing with, say, perjury. One, if you're still on direct,
I don't like
you can
it.
try to fix it up as you're going on direct. Or if it happens on cross-examination, you can try to fix it up on redirect. Another option would
That
be
part,
the
Jedi.
defendant finishes his testimony. You tell the trial court something very important came up during his testimony. If we could just have a moment to talk, if we can just have a little bit of time, then at that time you talk to them, you investigate whether or not perjury happened, you remonstrate with them about your ethical obligations and his obligations, and then you would call him back as a witness. And then if the trial court were to be like, well, why are you calling him back as a witness? You could either say it'll become clear in just a moment, Your Honor, or you could tell them, you would just have to tell them straight out, perjury was committed and I have to fix it before the end of this proceeding.
Well, his argument is more
One other thing I
concise
just
because
wanna-
it's
since I have
coming
a little
from the
bit of time,
state,
it's just
but
the rule that we're advancing, it is the rule that
Villarreal's
I believe
attorney
supports
was
federalism.
absolute ass.
It's the rule that what they're asking to do is put a rule that is virtually unalterable because it would require a constitutional amendment, and we very rarely micromanage trial courts in that manner with these kind of constitutional rules.
Let me ask you about your.
Here's the problem. If you're making the argument that it violates their right to counsel, a right is a right is a right. You don't get to draw lines in the sand. That's not how this works. This drives me insane.
Your perjury
Sorry.
exception. So
It's driving me
say
crazy.
that the defense counsel could advise the defendant when there's a break during cross-examination.
Fucking happy
overnight
SCOTUS
break
season,
during
everybody.
cross-examination.
I'll be live
To
for the
avoid
next 2
perjury,
days
doesn't
in the
that-
morning
would
at
that
9
allow
a.m.
Defense counsel to
for oral
help
arguments.
to clean up all inconsistencies between what the defendant said on direct and what the defendant admitted under cross.
So Could you phrase that one more time, Your Honor, just to make sure I understand?
Yeah, on direct, the defendant testifies the way it was anticipated before trial and says A. And then on cross, the defendant messes up and says B, something that's completely inconsistent. Doesn't that allow the defense attorney to say, look, you're under oath, you can't commit perjury, clean up what you said on cross-examination? That would be allowed?
I would say this. You would want to investigate with them to see if there actually was perjury.
Oh, no.
And then you need to remonstrate
Not
with
the
them.
maritime
And then you would
law
tell them,
FTT.
okay, tomorrow what we're going to do is we're going to clean this up. I'm not going to tell you how because I'm under court order. But just know, be expecting that tomorrow this is going to be fixed. You don't need to tell them, okay, here's the best thing to say, or, true or false. This is the best thing to say. I'm going to ask you these particular questions, so be expecting these questions. That's all strategizing. You couldn't do those things. But what you could do is just establish that perjury was committed and let the defendant know this is going to be dealt with tomorrow.
And how about the same thing with the question of plea bargaining? Could defense counsel say, wow, that was not good because you were mumbling, because you were scowling, you better correct all the, you better correct all that stuff?
No, FTT.
I don't think that would be
Go
allowed.
away.
What
I don't
we
do
say in our
soft
brief
sits
is
on
that you
Supreme
can tell
Court
them-
oral arguments.
You
Go
would
away.
say, you need to take the plea bargain. You might need to take the plea bargain because the state's case was so strong, but also if he just did a terrible job. And if the defendant says, well, how did I do a terrible job? You would just have to tell them, I'm under a court order. I cannot tell you why that's true. But you need to be, in my professional opinion, you need to understand that the best course of action for you now is to take a plea bargain.
Sovereign citizens are not facts,
Mr.
FTT.
Worthen. I
Now
mean,
shut
if
up.
you had said, as you do on page 14, that you can talk to the defendant about trial testimony when it's incidental to a big trial strategy
Which criminal,
decision,
though?
like
The
whether
state
to
of
take a plea
Texas or
bargain.
Villarreal,
And
the
the
murderer?
person says to you,
Which criminal?
I don't understand. Like,
DTIA?
what do you think went wrong? Like, why was it so serious that I now have to tell this?
Oh,
And you say,
FTT,
I
shut
can't
up.
tell you,
Somebody
just
mute
trust me that you
FTT. I
have to
can't
take
deal
a
with
plea
that shit
bargain.
this morning.
And the person says, what do you mean trust me? I mean, I want
Well, thank
this,
you.
I want to understand, like, why this went so wrong that now I have to completely alter my understanding of what
Love
I'm
you,
supposed
Ari.
to do here. Like, shouldn't the lawyer be able to say, here's what went wrong, here's why it's really consequential, here's why you should take a plea bargain?
My time is up, but would I be able to answer, Your Honor?
Sure.
So the reason is because you're going to be managing their testimony. And the whole point of the order, and all the logic behind Perry is that you should not be able to do that because you're basically telling the defendant, well, if you stop mumbling, you start looking the jury in the eye and you start giving clearer answers, well, then you won't have to take that plea bargain. It would be too easy of a workaround. Now, here's another thing you could do. You could tell them, I think this is going really badly. You probably need to take, in my professional judgment, you need to take this plea bargain. If they ask why, you say, I can't tell you that right now, but let's talk again whenever your testimony is over and see how it goes from this point on out and see where we are then.
Thank you, Counsel. Justice Thomas.
Okay, if you're coming to your client and being like, I can't tell you why, but you
guess I
suck
would've
and
thought
you
that
need a plea
discussion would be
bargain,
incidental
there's
to
a
the plea
whole
bargain.
problem there.
You say that you can
That's
discuss
the
direct
craziest
testimony
shit I have
so long as
ever
it's
heard of.
incidental to some other purpose. Why wouldn't it have been
I
incidental
could
in that case?
never,
Plea
ever.
bargaining is incidental. Like discussing a plea bargain is a general matter, but the main thing about our rule, at least, is that you not then turn that into an opportunity to manage the upcoming testimony.
Cannot with this shit.
Ms. Gamma.
It's going beyond.
Justice Jackson. Thank you, Counsel.
Thank you.
That's the question, Sarah.
Mr. Chief Justice, and may it please the court. In Perry, this court held that a criminal defendant, like any other trial witness, has no right to discuss his testimony with counsel after that testimony has begun. That principle is consistent with Getters and with a long history of sequestering witnesses in order to safeguard the truth-seeking function of trial. Because a defendant has no right to discuss his testimony midstream, an order barring discussion of only that testimony and nothing else is constitutional, just as a defendant has no right to a timeout in the middle of testimony to confer with
It's
counsel.
not.
Petitioner's claim reduces to the assertions that qualified conferral orders are unworkable because testimony can't be distinguished from other matters, and unnecessary because courts can just prohibit coaching.
I don't know who
Perry
this is
squarely
right now.
rejects both of those propositions, and it explicitly endorses qualified orders of the kind that was issued here.
No, it
The
doesn't.
court should therefore reject petitioner's request to categorically foreclose such orders as a matter of constitutional law for not only the federal courts, but all 50 states. I welcome the court's questions.
Under your approach, what can counsel discuss with the petitioner?
So there are many other trial matters, Justice Thomas, that the defense may want to discuss, from other witnesses' testimony to physical evidence, to strategies for the upcoming closing argument, to grounds for appeal, sentencing matters. Under our line, they just couldn't discuss the testimony itself. And we think that's a clear and workable line. We don't disagree with Texas's proposed narrower approach to account for the narrower scope of the order here, but we think our line is very clear and very workable and consistent with the Sixth Amendment.
Why is your line? Sorry. Why is your line better?
We're listening
it's
to
somewhat
Supreme
clear
Court
because we do
oral
think that
arguments.
there is
This
some
is
ambiguity
opening
about
day.
what management would mean, as Justice Gorsuch
We're
was
listening
getting
to
at,
Villarreal
how you
versus
account
Texas for
incidental
people coming in.
discussion of the testimony versus non-incidental. So, for example, we agree that there would be real concern to allowing the defense to say, or the defense counsel to say, you know, your testimony about this specific issue didn't go well today, and by virtue of those defects in your testimony, you should now consider pleading guilty. That does seem to us like, as Mr. Warthen suggested, an obvious workaround, and we do think that that would threaten the truth-finding function
Lawless.
of trial.
It's SCOTUS
so our
season.
rule accounts for that. We think
I'm
it's a
gonna be
reasonably
busy.
clear rule because, first of all, it's drawn straight from this court's decision in Perry. This is exactly how the court phrased the scope of permissible qualified orders in footnote 8 of that decision. And defense lawyers could apply it, I think, pretty easily. There are always going to be edge cases under any rule, but the defense lawyer can always ask himself under our rule, is this a conversation that I would be having with my client, irrespective of whether he was testifying in this case or not? And if the answer is yes, then he can have the conversation with the defendant. And if the answer is no,
I think we're
then he
in
should
rebuttal.
Is this, I had trouble getting my hands around what you meant by this on page 28 to 29 of your brief. You list a variety of matters that are pertinent to the trial.
Hold on.
And then you said those and other matters may be related to the defendant's testimony in the tangential sense that they bear on the trial context in which the testimony is taking place. A defendant and his counsel can conceptually discuss such matters without veering into the problematic ground of the ongoing testimony as such. I find that a pretty hard line to get my hands around.
I think, Mr. Chief Justice, our point there was that just because the testimony necessarily relates to other matters that the defense may want to discuss, the kind of matters that I was going through with Justice Thomas, that doesn't mean that you have a constitutional right to discuss the testimony itself. So, for example, if we went back to the plea bargain example, if the defense lawyer went into the recess and said to his client after the testimony had begun, I now advise you that you should pursue a plea bargain, we think that would be permissible, even if in the defense lawyer's head, part of the reason why that advice was being given was because he was aware, in the parlance of this court's decision in Perry, he was taking consideration of the testimony. That doesn't mean that you're discussing the testimony itself, and that doesn't mean that the kind of dangers to the truth-seeking function of trial are presented by that kind of discussion.
So he can ask them about all sorts of things that bear on the testimony, right? That might be pertinent in any other context that you just say, are they the sorts of things you
Your
would talk
client's
about?
testimony is a matter of public record.
Without regard
To
to the
the
testimony?
user, bunch of numbers in the comments.
Can the testimony at least narrow the topic of conversation you're going to have?
It's not some sort of like
I think that,
sealed
again, the
deposition.
topics that you would discuss can certainly relate to the testimony. We're not disputing that because the testimony is necessarily related to the other issues that are going on in the trial. All we're saying is that even under our rule, which is somewhat broader than Texas's rule, it is not a rule that you can't discuss, as Justice Jackson was suggesting, anything that relates to the testimony.
Thank
That's
you
not-
to everybody coming in for the follows. I can't pause these, so
correct.
I do
But
try to
what
keep
if I don't
quiet as much as
understand?
possible.
You really are objecting to discussing any kind of downstream effect or strategic consequence, including the need to call another witness because the defendant on the stand may
No,
have
there's a
introduced
bunch of
topic
split circuits on
that
this.
now
Use a
the
bunch
lawyer
of
wants to
numbers.
say,
I
"Do
think
you
it's a
know
9 to 4
anyone
split.
who, you said X, so it would be good for us to call a witness to address that. Is there someone we can call? Not protected.
Correct. I think a couple points on that, Justice Barrett. So first of all, we are acknowledging the fact that our rule is partly prophylactic in nature. So we're not saying that the Sixth Amendment rule needs to be tailored specifically to communications that
Go to the
directly
Supreme Court
impede the
website.
truth-finding function of trial.
They record
We think
all
that there
their
is
oral
some
arguments.
virtue to having a clearer, more workable rule, even if you can imagine
This is just
discussions
live.
under that kind of rule that would be prohibited that may not directly affect the truth-seeking function of trial. There's no narrow tailoring requirement here. The other important point I think I need to make is that we can all readily imagine, and we've been discussing
Thank you, everybody.
this morning, important conversations that we have the intuition the defense should be able to have. But if petitioner got his wish, and if all defense testimony or defendant's testimony were conducted continuously without a break, then by definition, this kind of opportunity for those discussions would not arise. So the opportunity to discuss potential perjury wouldn't come up because there wouldn't be a recess fortuitously intervening. So the notion that the Sixth Amendment rights of the defendant should turn on the fortuity of that recess strikes us as far-fetched, and that's what drove us to adopt the
Well,
position.
that's what we did. You may not like it, that fortuity, but we created a difference between Perry and Getters. And I don't think the difference was based, as you think, on the truth-seeking functions. That has a reason for the order. But Getters was very clear that there is an independent Sixth Amendment right for advice of counsel. And what you're seeking to do is truncate that right overnight so that if the defendant mentions the name of a witness, he says, do you have the contact information for it? He's not affecting the testimony. He's not asking the witness to change it. He's not talking or evaluating the testimony. He's simply saying, give me an address. And you're saying no.
I wouldn't say no.
That was
if you're
a
just asking
banger.
for the address.
That was a
But
banger
you
from
see
Sotomayor.
You're trying to cabin what
Oh,
is
wait, no.
obviously not logical in your
That may be
extreme
Kagan.
position. The same thing.
No, I think it's
with
Sotomayor.
The plea bargaining situation. I find it impossible for a lawyer to
We know.
say, I think you should consider a plea bargain now. And that the defendant is
Yeah,
not
that's
gonna
what I was
say,
thinking, but
why?
Kagan kind of has a little
the
bit of
why
like
has
the
to be my
New York
considered
accent, so it's kind of like
That
a little
gets
bit
me from
different.
here to
I
the
like New
corner and
England,
back.
sorry, not New York specifically.
With nobody paying me, okay? You need to say something. The model rule says a lawyer shall explain a matter to the extent reasonably necessary
Yes,
to
it's
make
Sotomayor.
an informed decision. Now, if you have a rule that says you can't manage the testimony, but you can evaluate the testimony and say it was pretty bad for lots of reasons, that should be okay.
So I
Sorry,
certainly
I'm bad
want to
with
repeat,
voices,
Justice
guys.
Sotomayor,
I
that we don't
apologize.
disagree with Texas's rule. And if you wanted to say that because this order in this case was narrow enough to
They
trust
kind of
for
have
the
similar
management of the
inflections
testimony,
on things,
we're gonna
but
say
like
that's permitted by the
it's
Sixth
kind of one of
Amendment.
those
That's fine with
where
us,
I
as long
can
as you don't
cross it
suggest that
over.
that's all that courts can do,
That's the no.
because I think that's an important point. And if we got
That is an important point, because what you're asking us to do is to
I got you,
potentially
Davina.
say you can bar all conversation here.
about the testimony, but you can leave that matter for another day.
Why? Why would we do that? I guess I don't understand. If this order is narrow enough
It's Jackson.
to cover the concern about problems with truth-telling in the trial, because we are keeping the defense counsel from managing the way that it's been described, why would we go further to ensure that there could be problems with the Sixth Amendment by suggesting that a court could?
Johnny, you're
do
not going to
more?
be comfortable listening
I
to
think that
SCOTUS
just
cases
because
then.
this order satisfies the Sixth Amendment doesn't mean that a somewhat broader order could not, especially when we account for the fact that trial judges can be trusted to tailor these orders depending on the specific nature of the case, the nature of the defendant, the nature of defense counsel. We do think that there is some virtue to a somewhat broader rule, just in the same way that And if I may continue, Mr. Chief Justice.
Thank you, everybody.
Just as we ban defendants regularly from having any contact with witnesses in the trial, we don't ask, can they be banned just from having
No, they are
threatening or
there to
detrimental
answer
contacts
questions
with
so the
witnesses? It's the same
justice
kind of
can
principle.
decide on
Justice
whatever they're arguing for. That's what they're there for.
Justice Kagan? Justice Barrett?
What's
Hey,
your
Butterfly.
view of what the original text and history would tell us about the proper rule pre-Getters?
That's a very good question, Justice Kavanaugh. So the root meaning of the Sixth Amendment counsel clause is simply the right to retain counsel. The amendment was adopted, or that clause was adopted to abrogate the common law rule that felony defendants generally had no right to counsel at all. One of the things that we think is very important in this case is that even the root meaning of the right to counsel, which is the right to counsel of choice, is subject to broad limitations. This court has said many times that a trial court has wide latitude
That's their fucking
to balance
job,
that
Johnny.
right, that core right, against countervailing considerations like fairness, like the demands of the court's calendar. And that's another reason why it's appropriate to have a somewhat broader prophylactic rule and to reject a kind of narrow tailoring requirement in this context.
Justice Jackson?
I guess I'm still just confused as to why a narrow tailoring requirement. So can you just say more in response to Justice Kavanaugh? I mean, we have a Sixth Amendment right. I think you agree to have counsel have access to his client about trial strategy, about matters that he's allowed to talk to him about. And so in a world in which your prophylactic rule potentially encroaches on that because some of those trial strategies are intertwined with his testimony, I don't understand why we would give the court the ability to preclude discussion of any testimony.
So, Justice Jackson, we're just drawing the line that this court drew in Perry, and I think this is what Justice Kagan was getting at earlier. The court in Perry drew the line at discussion of testimony versus discussion of other matters, and that's the line that undergirds the basic holding of Perry. The idea is that because during the 15-minute recess at issue, which is taken sort of in the heat of the testimony when it's top of mind, the only thing likely to be discussed during that kind of recess is the testimony. That's the way the court phrased it.
And if we read that to mean testimonial management, what then?
Well,
not strategy as a result of the testimony, because we don't have time for that in 15 minutes. The 15-minute window in Perry when it says...
I'll tell you what I really want them to get into is what do they mean by management? What is this
during that 15 minutes about what he just said or what he should say, and that's off limits.
Right. So if you agree with Texas and with us that the order here is reasonably read as just prohibiting management of the testimony, then this case is a very easy case because Perry clearly says that that is constitutional under the Sixth Amendment. Leave for another day whether the SG is right about this potential broader rule. That's all you need to do.
Thank you.
Thank you, counsel.
You are right, Attorney Stara? Sorry, I don't know what your name is, but you are correct.
Three quick points.
Most of them
That's all right.
has never been a
First,
defense attorney. They all
under
came
the
from
Texas
prosecutorial
standard,
backgrounds.
the court should
We went over
reverse.
that earlier.
The trial court and the state appellate courts understood the order to bar many of the kinds of discussion that Texas now says is permitted.
Thank you to everybody coming in.
The court's
trying to shut up because this is live.
To my friends here suggest that the supposed line that Texas is no line at all. Lots of questions about what about this, what about that, and so on. Different trial courts are going to draw that line differently from the way my friend from Texas draws it. Defense lawyers will have no idea what they're allowed to discuss and what they're not allowed to discuss. And so, of course, they're going to err on the side of not discussing, as trial counsel did here. Finally, for decades now, the majority rule in the United States has been that the defendant has a right to the complete discussion of testimony during overnight recesses. It's been a very clean rule, unlike the rule that Texas and even the United States advocates. And it's the right rule because strategizing about testimony is one of the most important things that that defense lawyers do. It's one of the most important kinds of assistance that
Oh, but
defense counsel
Stara,
provides.
this attorney is
Thank you, counsel. The
absolute
case is
ass
submitted.
crack. I don't know why Villarreal, his argument at the beginning was terrible. Did I lose it? Are we good? We donesies? Okay, we're donesies. If anybody would like to come up, I got like 30 or so minutes to kill. You're more than welcome to come up. Wait, let me try again. Hold on, I'll double check. Nope, nothing. We're good. But anybody's welcome up. We got about 30 minutes of discussion time, but this was a super interesting case. It came out of my home state of Texas. I very much wanted to see where they were going to go with this. Hey, Lawless, I am pretty adamant in my thoughts that
It's 24-440, Burke versus.
sorry, I'm not listening to Burke. I was pretty adamant in my thoughts that, like, I fundamentally believe that we shouldn't be treating defense attorneys as potentially in violation of the law. Sorry, I'm having issues with my background right now. But we shouldn't be treating them this way. They're attorneys. They have many rules set in place already. They know not to suborn perjury. Like, this is not complicated. And I think that preventing a defendant from discussing with their attorney, particularly during an overnight recess, is a violation of their Sixth Amendment. What's up, guys?
Hey, thank you for pulling me up. I'm in New York, 57. Yeah, I just went through a trial that took 2 years that I went through, and it was done specifically through family court. And it's insane to think that, number one, that my attorney who represented me would not be able to communicate with me if we, a trial takes a couple of days, it could take a week, it could take time, that my attorney wouldn't be able to speak to me about what happened and explain to me, like, some of the things that happen in a trial. Sometimes, we don't know.
So, sure, this is really super specific to, like, their, like, while they're giving testimony on the stand.
Yes.
But I fundamentally feel like you're preventing an attorney, like, you're not only limiting what they can talk about, but you're preventing an attorney from having that conversation with their client. I feel that that's ultimately problematic. I felt like the lawyer that was arguing this was still trying to draw the arbitrary lines that existed. I felt like they should have just made a full argument that, like, you can't prevent a defendant from utilizing their attorney. That's just my take on it, because attorneys, like, suspecting that they're not representing somebody, like, and they're charged with a crime, they have their own ethical rules and standards. I feel like you're kind of treating them as a criminal, and that's not the case.
You said it
Yeah,
before.
like, I'm sorry.
You said
I was
it before.
just saying.
Sorry, go ahead.
I'm sorry. Let me just finish my thought and then you can go. Like, when I was on trial, right? Like, I had to testify. And then the following day, there was the rebuttal. My attorney had to speak to me to prepare me for whatever I may have said on the stand, to better prepare me the next following day of how I'm going to respond and how to make sure that my answers are not going to be harmful to my case. So that's insane.
Sure.
And that's where it kind of gets sticky, right?
Mm-hmm.
Because now you're advising, like they're talking about, on strategy of the trial and coaching of the answers. But Cass, would you think that's permissible?
I mean, like, okay, so I don't know, it's complex, right? Like, there's more than one answer to this, but, like, presumptively, your client should already be aware of all this before they get on the stand. Any sort of coaching or management or whatever they're wanting to call it in SCOTUS, which is where you're talking to your client and saying, hey, You know, these would be the way that I would answer this question, and things. This should all be done before they're giving testimony. I don't think that you should be prevented from telling your client, hey, you were giving shit testimony. We may need to take a fucking plea. Or what the fuck? What was this answer? I mean, if that may not be like routinely acceptable, but I don't think it's wrong.
But I think I'm with
Yeah, but
you. Sorry,
it's not only that. It's the fact that, maybe I said something on the stand that I didn't, this is all about framing, right? We are not experienced when we take a stand. So this is about framing. So it's not about managing us. It's not about coaching us. It's about explaining to us what we may have said may open the door to something different and understand what we're saying. So I don't consider that coaching. That is explaining to us how the process is, because we as a regular citizens don't go to court every freaking day and sit on a stand talking to a judge.
But it's changing your
protecting
behavior.
our rights.
It's changing your behavior while you're an active witness, though, too.
Davina, your name, that's how I say your name, right?
Yeah.
Okay. I was like, I'm only here for 5 minutes because I have to leave for a doctor's appointment. But I just wanted to say, yes, I fully agree and understand what you're saying, because you can say the same thing. I can say the exact same thing to a class of 10th graders, to a room full of colleagues and staff, and to a room full of the higher educated professionals within, it's the same thing that I'm saying, but I'm saying it in different ways because I'm code switching according to my audience. And if you aren't used to a court audience, then you do have to be trained in how to say the thing and how to code switch appropriately. So I agree. That's
Okay.
all.
Quickly, before anybody else talks, because I have a kind of Sarah in the comments. Absolutely not. That's what this entire case was about. The defendant was prevented from talking about their testimony on an overnight recess. So we needed to cover that. Anyway, sorry. Thank you, Parkers. Chill, Betty, what's up?
Everyone bought the screen. Thank you.
Oh, thank you, Parkers. I love you.
Can you hear me okay?
Yep. Yes.
All right. So, I'm totally blown away by this. When I seen it, this is unreal to me. I've never been the defendant. I've never been the criminal on the stand. But to me, and I don't support criminals. I used to be a cop. I'm not pro-criminal. But to me, I need to be managed. Okay? To even say that my attorney shouldn't manage me is totally incorrect. Okay? Because I need to be managed. That's why we hire these guys to handle this for us. And most criminals should not testify. I mean, they tell you that all the time. Don't fucking testify, because you're going to open your mouth and say shit you're not supposed to.
And I want to point out, in Villarreal, the only reason that he was on the stand is because he was testifying that he made those moves in self-defense. So he had to attest to this on the stand. Otherwise, I doubt his attorney would have put him up there. I agree with you. Generally, that's probably not the move.
So, but that attorney needs to be able to, do something other than baseball hand signals at the desk saying don't speak. Because when you're a criminal, what you say could hang you, literally. So, that Fifth Amendment protection is there for a reason, and your lawyer should be able to step up and say, hey, he's taking the Fifth.
Okay, people in the comments, Villarreal was convicted of fucking murder. I think they're doing a 6-year sentence right now. So yes, they were indeed convicted. It's probably part of why this case is at SCOTUS right now.
Hey, Betty, did you ever testify in a criminal trial as a police officer?
No.
Okay.
No, I only did it for a couple of years. I was a hard-headed child, and I was pissed off at my dad.
Cass, I'm kind of with you. The right to counsel is a right. You are entitled to that. And the idea that an attorney may violate what I would consider to be an ethical violation about discussing things they shouldn't, that the scales tip clearly in one direction for me on that.
Well, and see, that's the thing is like, I didn't like the argument that Villarreal, the attorney representing Villarreal was making, because they were trying to like reinforce the arbitrary lines between like Perry and Gators, right? Like the two cases that are like, well, what if it's a 15-minute recess and what if it's an overnight recess? The argument that should have fundamentally been made was that if you are a defendant, your Sixth Amendment guarantees you a right to counsel. You don't get to arbitrarily decide what they can talk to counsel about. Otherwise, that gets into a whole problematic range of things that, like, how far will they go? Like, it's kind of like you give them an inch, they take a mile thing. And I honestly believe, like, it also penalizes the attorney because you're treating them as if they are going to violate their ethical conduct. Why?
So you think not only should they be able to consult at any time, there should be no limits on what they can discuss?
I don't
Absolutely not. No.
Okay. Yeah, I don't think that there should be limits on what they can discuss. Obviously, they can't suborn perjury. There are certain ethical limitations there made for attorneys. But like, if you're just having a conversation with your client, no. There is a difference, though. The one addendum I will give that SCOTUS did bring up was like, what if they're actively on the stand? Of course not. That's insane. That's like gonna like rapidly interrupt a court process. But if you're on a recess, no, I don't think you should be like barred from being able to talk about testimony. That's ridiculous.
So let's say you're testifying on an afternoon. It continues on into the morning. You meet with your attorney after court that evening, and the next day someone almost completely different singing a different tune comes back to the jury. Like, because the attorney gave them guidance overnight, right?
Then, okay, but that's the thing that they had mentioned before, which is, well, that's a question that comes up on cross-examination. Well, why were you saying this, Monday, and then saying something different Tuesday? What occurred? Those are questions that the prosecution, in this case, would be obligated to ask.
Yeah, for me, in my novice mind, there should be a line somewhere, because I don't know. You shouldn't be able to instruct them to say
Where do you draw the line at what you can talk to your attorney about?
And that's the messy part, right? When they're on the stand, we're talking in the context of when they're on the stand, right?
Yeah.
Yeah, that's where it gets messy.
I mean,
I thought the court case was about a recess, right?
Hold on real quick. I promise I'll answer your question. Give me just a second. It's kind of like this presumption. We know that you talk to your attorney about your testimony, like pre you giving this testimony. Like, you're going to be having discussions about what you're going to be saying, doing, questions you're going to answer, not to implicate that they're like suborning perjury or anything like that, or violating their ethical implications. But like, it is a standard that you would be discussing your case, potential testimony, things like that. Why does it change? Why is it suddenly different? That's
and I agree. I buy that argument as well. So
Yeah.
that's why I'm torn.
I'm sorry, Betty. Please.
Because it stifled. I thought we were talking about the whole recess. I'm totally pro the attorney giving hand signals. Not interrupting the court, but giving hand signals for when you're on the stand if you need to be, because your life is literally on the line. But the only reason I could see that they would try to stop an attorney from talking to their client for a 15-minute recess or an overnight recess would because not because he's telling him to perjure himself, but because they don't want the attorney trying to calm a frustrated client down. Because a frustrated person will say all kinds of stuff that they actually do not mean.
Well, it comes from this like arbitrary idea of like this pure testimony, right? Like this uninterrupted testimony. And the simple fact is, from the second they get on the stand, if they have arguably had an attorney up until the point of trial, they're never getting on the stand with pure like That's not the way this works. There is a reason that you hire attorneys. There is a reason that you employ attorneys. And it's not because they're pushing their ethical limitations. It's because they're making sure that the state makes their case beyond a reasonable doubt. And they are making sure that you are represented to the best of their ability. Part of that includes going over things, questions you will be asked, testimony that will be given. Like, I don't know why it's an argument about pure testimony, but only when you're in testimony. It's just odd. Like, I find this to be sort of like almost an odd presumption in general.
I can't believe this hasn't come up before.
No, it's come up many times. There's Perry, there's Gators. The circuits are split on this. Like, that's why, like, I think this is such a good question. Star pointed it out. I had pointed it out earlier in the live. Most of these justices come from a prosecutorial background, and you saw it. You saw it in the way that they framed the questions. You saw it in the way that they talked to the state versus Villarreal's attorney. You can sort of see the trajectory of the way this is going to go. I think that they're going to side with the Criminal Court of Appeals, that like, oh, there can be this like sort of this balance, which is odd, like, to me, because I do feel like it's a fundamental violation of your Sixth Amendment right.
Yeah, it really does sound like that. But if they really wanted the pure testimony, why couldn't they say, okay, when it comes time for this person to testify, they're going to have a recess, and that person's going to be the first to testify at 8 in the morning.
That's just not the way the court layout works sometimes. They just kind of go how they go.
Yeah, but that would be the most reasonable thing, to make sure that they are the first testimony of the morning. If your client is going to testify, you guys can get it together and schedule it. I mean, that they can get their shit together, and they can say, okay, we've got all this other wrapped up. Now it's time for his testimony. His testimony, if they want to violate a right, because there is nothing in the Constitution that says you have your right to your attorney. It doesn't say except when we don't feel it's convenient. There's no exception on that. It doesn't say except when we don't want it.
Well, no.
So if they're going to try and stop you from speaking to your attorney so they can get pure, they can get their shit together, and they can schedule them to be a first testimony for the entire day. That way it's pure.
Yeah, but that's not how the court system works. That's not how testimony works. They go in order, like it just doesn't work that way.
And they could be up there for 2 or 3 days.
Yeah, like literally sometimes you can be up there for 2 or 3 days. Depending on the testimony you're given in any given case, you could be up there a while. And a judge isn't going to do that. Thank you, Star. Yeah, they don't give a fuck. They don't give a fuck.
Man, I'm just so struggling, because if the conversation were unlimited and an attorney didn't like how you answered some things, you could have them reopen those questions in a different answer the next day on the stand. You could kind of revisit something, water it down.
I can agree with that. I can agree that that's potentially an issue, but also that comes up in cross. Like, the state has a burden to meet. And that's what bothers me about all of this, is that like the state has to meet their burden. I can see that like maybe like your attorney could do some like, but it's not like attorneys are not educated people that watch, take notes during a trial, know when something changes from one thing to the other, from one day to the next, right? Like, those are things that they are trained to do. That is their whole fucking job, whether they're a prosecutor or defense attorney. So like the simple thought that like a lawyer could do this, sure, perhaps they could, but that's also something that comes back to cross. Like, if the state can't cross-examine, that sounds like a fucking skill issue, man.
Yeah, and I'm not talking about switching a yes to a no. I'm talking about maybe adding in a detail that provided more context that you forgot the previous day.
I mean, But like, what's inherently wrong with that? To that point, right? Like, if like, say this is a murder case, right? Like, life is on the line. You're spending life in prison, things like that. I mean, first of all, it's a presumption that they would add more detail because they're not going to be discussing what they discussed with their client. But even if they did add on more detail to like elucidate something, right? That only gives their client a better fighting chance in front of a jury.
Yeah, I agree with you and Star. If it's true, you know, the facts should come out regardless, right?
Exactly.
And they may meet with a lawyer. The lawyer may not coach them on any of that, and they may do it spontaneously on their own the next day, and then you assume it's a result of that. So it really does get messy there. So maybe I'm with you more, Cass, that it's very difficult to draw a line and to honor that line. So maybe there just shouldn't be one.
Well, I think like if you're going to say that they have a right to counsel, like all it comes down to at the end of the day for me is this. It comes down to the Sixth Amendment. They're guaranteed a right to counsel. They're not guaranteed a right to counsel, but they're not guaranteed a this but that. Like now, if a client, obviously there's certain ethical implications. You can't come to your lawyer and say you're like involved in some ongoing criminal activity. Your lawyer can't tell you to lie. You know, obviously there are ethical and reasonable implications for lawyers. I expect them to adhere to those. If they're not, that's certainly a problem and that should be addressed. But the simple fact is most lawyers who went through 7 years of school, worked their ass off, are paying thousands of dollars of student loans to be like a public defender, are not losing their law license for some jackass. Like I said what I said. I'm sorry. It is what it is. They don't fucking care. Like, they do not care about you enough to lose their law license for you.
What was the decision? What was the decision? You said the circuits are split on this?
Yeah, I could be confusing two different. I think it was like not 9-4. There's something. Hold on. Let me see. Let me pull the writ because the writ has it. Give me 1 second.
And Dana, go ahead and introduce yourself. I'll take care of some housekeeping while she's busy.
Thank you. Yes, 9-4. Sorry, 9-4. Dana, what's up? You are live on TikTok. God damn it, Canine, you motherfucker. No, DoorDash attorney has not weighed in eggs. Dana, hello, you're live on TikTok.
What? I didn't mean to do.
Hello.
Yeah, hang on.
Cool. Okay.
Cass, how long have you been following this case?
I remember it from actually when the murder occurred. And then I followed it like briefly through Criminal Court of Appeals. I won't say like I'm any master on this case. I just kind of followed sort of what was going on. And then I saw SCOTUS picked it up.
Stop. From Syria, need help, please.
We're not doing that today. And then I saw SCOTUS had picked it up, and I was like, ooh, cool. So I just thought it was interesting and figured, why the hell not?
So there were 3 attorneys arguing, right?
Yes, I believe. I do not know who the third one was. I'm making a guess based on an amicus brief that was filed. I think it was actually Ohio because they specifically said Texas who agrees with us. And I didn't hear the attorney be introduced, so I'm just guessing. It was probably Ohio because they filed an amicus. That's my guess, but don't quote me on that. I'd have to go to the transcript.
But when you file amicus, you must have to also petition and then be granted the right to appear in oral arguments, right?
Yeah, I haven't looked that far into SCOTUS blog's documentation or the SCOTUS documentation. So let's see. Circulated. Blah, 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 blah. Yeah, I'll have to dig through it. It'll take me a minute. But anyway, yes. So I'm going to go over my schedule for the week because I am actually covering SCOTUS for the next 3 days, or 2 days, sorry. Tomorrow I'm going to do Chile versus Salazar, and then I'm going to do Boss v. Board of Elections. Let me see.
There's another case today, right? Another argument?
Yeah, I'm not doing that one though. I only do the ones that like I'm actually interested in. So Chile versus Salazar is this case about a Colorado rule, a therapist, and the First Amendment. Basically, okay, so I'll tell you the question that's asked. Whether the law that censors certain conversations between counselors and their clients based on the viewpoints expressed regulates conduct or violates the free speech clause. And then Boss v. Board of Elections is going to be whether petitioners as federal candidates have pled sufficient factual allegations to show Article 3 standing to challenge state time, place, and manner of regulations concerning their federal elections. So all of these this week, they're pretty much bangers. The second half, though, not so much, but the first cases at 9 a.m., well, 9 a.m. my time, 10 a.m. Eastern, are all bangers this week. So
Do they usually take cases of high interest early in the term?
it really just depends. Like, honestly, sometimes they're really good, sometimes they're not. It's just kind of meh. Like, I never know. But when I was like going through, because I was like, you know what I'm gonna do? I'm gonna just start covering these in the morning because I can work whenever because I work remote. So I'm like, okay, cool. I'll just do these in the morning. And I was like, why not?
Yeah, it's going to be a wild term. Lots of action.
The name for the case tomorrow is Chile v. Salazar. It sort of is revolving around a therapist who is very like, I don't like gay people, and like religious conversations within the religious viewpoint that God wants us all to be straight within the context of a counseling environment. I'm going to read the cert petition for it. I kind of know a little bit about the case, but I'm going to read the cert petition. So, yeah.
So the counselor was expressing specific views within a therapy session, and the client ended up suing for that?
So no, the counselor is suing, well, they were suing Colorado, saying that their beliefs are, well, their topics of conversation were being censored by the rules that they have for counselors.
Okay, got it. So the government was limiting their speech in the professional environment.
Yes. Well, that's their allegation. We'll see. I think probably that's the way this is going to weigh out. Because again, it's under strict scrutiny, and suppressing certain viewpoints or forcing viewpoints not to be, they can be really problematic. So yeah, I'm going to bet that that's the way this is going to weigh out. That's my guess for now. But again, I haven't read the cert petition, so I can tell you a limited amount of information about this case.
I always hate seeing the rulings fall along ideological lines, but these get down to such fine issues that have, I don't know, a high level of precision might be the wrong way to put it, but you know, they're very like theoretical, abstract kind of,
questions
decisions.
of law. Yeah, like they're literal questions of like sort of the outskirts of law, like this, like, right? You can see it going both ways. But to me, I'm just going to bring it back to fundamentally what is guaranteed by the Sixth Amendment, which I don't think the justices will do in this case. But conversely, tomorrow, I bet you they're going to be really strict in the outcome of this next case, which is weird, right? Like, we should have the same level of like,
deference for your rights.
Of deference, right? Yeah. Like we should have the same, everything should be that way. But yeah, it doesn't usually play out that well.
So if you had to bet, you would bet that they uphold limitations of the state of Colorado tomorrow?
I would bet that they don't uphold the limitations of the state of Colorado tomorrow. I
Sorry.
bet tomorrow they're going to say that that counselor is entitled to their viewpoints and expression of their viewpoints. However, today, with the Sixth Amendment, I am almost guaranteeing they're going to say, we agree with the Criminal Court of Appeals. You can kind of like split this right like this. That's my guess.
If they're okay with allowing the speech in a therapy session of, what effectively I'll call the religious right, limiting homosexuality and that stuff, they have to be okay with it going the other way too, of trans rights, right?
Well, see, that's always the fun part about these decisions is they sort of set a tone that when this plays out in 10 years or when power changes over that they don't like I hate inconsistent people. If you're going to have a level of belief on something, be consistent about it. Don't waffle around. That's ridiculous. Be consistent. And it always seems like Mitch McConnell is probably my very favorite example of this for the Borking, everything that happened with Robert Bork coming after that and how he sort of managed and mitigated the Supreme Court to get the justices he wanted. And he sort of backed Trump for a while. And now he's like, well, I don't know that I agree with everything now that he's in full power. Bro, you played your hand and this is the outcome. So it's kind of you have to think in a very different level. And I don't think a lot of people do think that way.
Yeah, for me, all this is like the filibuster in Congress. It cuts both ways. And if you want it now to protect you, you're going to dislike it later when it's protecting the other side. So we have to be really careful with these precedents that are set.
1,000, I fully agree. And that's why, I think these cases eventually, people always talk about precedent, stare decisis and things like that. Sure, I agree, but precedent lives to be overturned, essentially. That's just kind of how it works. I hate when people look at it, well, it's precedent. Well, you get the right set of judges, it isn't anymore. People have different judicial interpretation styles, and sometimes that's just not the way it works.
And I guess that was my point before is these come down to such fine legal issues that you can argue the legality on both sides, and eventually you either have to flip a coin or just base it on your personal beliefs or, it just 6-3, there we go.
Yeah. I don't know. It's sometimes it's ideological split, but some of my favorite outcome cases are the ones where so Roberts and Barrett are an interesting set in this sort of 6-3 court.
Yep.
They're more of what I would probably like to say are institutionalists versus hardline this way or that way. They're really concerned with preserving the integrity of the court. Now, do I agree with everything that they've agreed with? Fuck no. There are a lot of things that I think that was terrible. But when I read their decisions, I can see that where their judicial style is taking them. People give Thomas a lot of shit, but he's probably one of the most ideologically consistent judges there is. Again, don't agree with them on everything, but still. So it's kind of interesting. And I always like the cases where Roberts or Barrett kind of tag out and they're I don't know. I always think that's a fun split, especially to read. So,
man, wouldn't you love to see what goes on in these deliberation rooms? I can't even imagine.
To be a fly on the wall, I'm telling you.
But I don't think there are any, right? I don't think there's any aides or any clerks or anyone in there, right?
That's a good question, and that I do not know the answer to.
Because if someone knocks on the door, I think it's the junior justice that has to go answer the door. So it's almost like a cloak and dagger.
Yeah, except for when Alito does WikiLeaks of the like Dobbs decision.
Was that him?
Well, we know he was. Yeah, I mean, it wasn't him. Like,
Right, but his chambers?
it was. Yeah, it was assumed it was like one of his clerks, I believe, or something like, or somebody that like worked around or had access to it. So.
Wow, that's crazy.
That's just like broad assumption. Of course, they never found the person who did it. Like, how many people are working there that you don't know who leaked this? Like that was always my question. Like, they're not that good. They're not.
It's all computers. It's not like they're handwriting.
I know,
It's
right? Like, how do you not know where that came from?
Yeah, exactly. I mean, it must be treated somewhat similarly to like top secret information. I mean, it must be restricted access, right? So.
Yeah. My tinfoil hat theory is that Alito leaked it by mistake, and then nobody wanted to say anything, and then nobody wanted to turn him in. So that's my tinfoil hat. I'm not saying that's what happened, just my tinfoil hat theory.
I'm sorry. I thought I was using my 2020 Project 2025 email account. I got them confused. It was an honest mistake. So, all right, I got to run here, Cass, but nice talking to you.
I gotta go, everybody, because it's 11. But I love you all. Thank you, Lawless. Have a great day. Everybody, thank you so much for coming in. Thank you for the follows, likes, and shares. And I will be back tomorrow with Chiles versus Salazar to talk about counselors and whether they should be able to talk about their Christian values in a system. So love you guys. I will talk to you soon. Bye-bye.